So welcome everyone, and thank you for being here today. Let me begin by introducing ourselves, the Fly Battle Academic Discussions. So we are a group of Iranian scholars and graduate students based on different countries and from diverse backgrounds, educational backgrounds. We want to engage in serious academic discussions, and that's why we have chosen this name for our presentation series. And if you are curious about the name of our group, the Fly Battle, I have to say it comes from a quote by Ludwig Wittgenstein, an Austrian philosopher, who said, "It is the very task of philosophy to show the fly the way out of the fly bottle." And that's what we want to do. So for that reason, we bring together scholars with a passion for arts, social sciences, and humanities to exchange research ideas in a friendly environment. And we emphasize on this friendly environment. And we are committed to freedom of expression, which is grounded in mutual respect. So the title for our presentation today is Frozen in Time, the Static Nature of Legal Texts and the Controversy Surrounding Dobbs. And it is my absolute pleasure to introduce our guest speaker, Homayoon Rafatijo, who is an intellectual property litigation attorney affiliated with Spencer Fane, LLP. His legal expertise is centered around various facets of intellectual property law, with a particular emphasis on topics such as artificial intelligence inventorship or authorship, the constitutional foundations of intellectual property rights, and estoppel doctrines. Before entering the legal arena, Homayoon served as a chemistry professor and held the position of president at the Association of Intellectual Property and Entrepreneurship at the University of Missouri, Columbia. So without further ado, Homayoon, the floor is yours.
So thank you, Medijan. That was a very humbling introduction. I very much enjoyed to be among you guys, and thank you for inviting me to the guest speaker here today. Everybody sees my screen?
Yes.
Oh, great, good. So yeah, the topic for today's academic discussion is about an idea of originalism when it comes to judicial philosophy. Now, of course, I get the date wrong. So sorry, today is December 10th. So I apologize. Just you couldn't be perfect always, right? So for some reason I can't. Oops. Okay, great. So with no further ado, I'd like to start my presentation. However, I need to make it abundantly clear that today we're not going to talk about the philosophical question of when the life begins. I'm not a bioethicist, okay? So I'm a lawyer. I mean, I used to be a chemist before. I still hold chemistry dear, but I'm not a bioethicist. So I'm not going to say anything as to that question. So if you are here to get an answer to that question, you are in the wrong meeting. Second, whether the topic of abortion is moral or whether it should be legal, it is not for me to say. I do not have a public opinion on that question either. So to be clear, today we are only talking about judicial philosophy that interpret the text of the law. So what other political branches of the government, i.e. legislative branch or executive branch, should do has nothing to do with today's talk. So I just want to make that very clear to set the expectation. And with no further ado, I like to start my topic, my talk, with one question. Suppose you are a judge, and again, for all of the slides going forward, we are talking about a judge and a judge only. I want you to put yourself in the shoe of a judge. Suppose you are a judge. what would be your main duty as a judge? Apply the law, and with the understanding that the law is not something that you have written or you may not agree with, or do justice. So we created a little poll here, and I would like to encourage every one of you to jump in, interrupt me, and let me know if you have any opposing ideas, because I'd like to hear from you. Hopefully by the end of the 2 hours we have today, we're going to learn from each other. So yeah, great, you get at it. And by the way, the poll is anonymous, so feel free. If you haven't already registered your vote, please do so. Okay, I'll give it another minute. And okay, I think, yeah, we stop the poll and share the results. And everybody can see the results? Or I have to, maybe, and you see the result?
We don't see it.
Okay, okay. So, it seems like I'm very much surprised. Usually I don't get this statistics. Usually it's the other way around. It's like mostly what I hear from people is that the judge's task is to do justice. Now, I'm not suggesting that the justice is something different from application of the law, but there are instances that the law as applied would not necessarily guarantee justice. In other words, in the court of public opinion, we might have a different view of justice. And even the judges who decide a case might share those views. However, when they are tasked to apply the law, the result would be completely unjust. So, of course, there are some overlaps. Sometimes application of the law is the way to get to justice, but sometimes justice as a common sense is something that's not achieved necessarily by the rule of law. Now, before I get a little bit further, I'd like to draw your attention to some scholars and famous judges' view on this topic. Now, there are two main American legal scholars. Both are deceased at this point, but they're very famous. One is Judge Leonard Hand, whom I guess every law student in this country know because of his impact on revolutionizing the area of tort law. And another one is Justice Holmes. Now, Judge Hand tells a story about one of his conversations that he had with Justice Holmes. The conversation goes this way, that he asked Justice Holmes to do justice. And Justice Holmes turns to him and says, "That's not my job. My job is to play the game according to the rules." Now, this story, this little anecdote here, has been recounted over and over and over by many scholars. One of the famous recounts is by Judge Gord, who was appointed by President Reagan to serve in the Supreme Court, and unfortunately, he couldn't get there. When he recounted this story, he says, Holmes in response says, "That's not my job. It is my job to apply the law." Now, I'm going to get a little more into the details of how he tells this story, how it is different from Judge Hand's version of the story. We're going to get to that point. But another scholar, the Harvard professor Case, he also recounts this story, and he says, well, Holmes kind of, acted like he doesn't know what justice is. Justice? What's justice? What's that? That's none of my business. The law is my business. Now, if you if you have a little expertise in discourse analysis, and just reading the stories that these two figures recount, you see some darn significant differences. Now, first, we start with a Bork story and compare that to Judge Hand's original story. Well, Judge Hand says he and Justice Holmes were walking together. They were jogging along in an old coupe. And then they just part ways, right? He walked off and they were walking. In Bork's story, Justice Holmes is in a carnage, is in the car. He's driving. So he's kind of giving the impression of Justice Holmes being in control. He's still in the car, and it's Judge Hand actually. It's just Justice Holmes drop off Judge Hand. Then it says, I said to him. Judge Hand says, I just said to him. The way Bork depicts the story is that Hand ran after him crying. You know, giving the impression that Judge Hand is like a little child, you know, ran after Justice Holmes and crying instead of talking to him, instead of asking him. Now here, Justice Holmes, he turned to Hand and he replied. That's Hand's story. But Bork says, Justice Holmes stopped and reproved. So reprove means like the criticize, right? You know, it's the position of authority given to Justice Holmes, a wise man who reproves, who not replies, who reproves. And then at the end, it says, my job is to play the game according to the rules, changed to it is my job to apply the law. You see, again, that's something that you heard from a wise man. So in Judge Bork's view, Justice Holmes represents a wise man. Now compare the way the story is recounted by the Harvard professor. Well, first of all, Hand called, not crying, not running after Justice Holmes, he just called. And it's the Hand who called on Justice Holmes. It's not the other way around. Second, Justice Holmes all of a sudden becomes the old man. The old man says this. And then turned on him instead of turned to him. Turn on him like he's an animal, right? He just, next, justice? What's justice? Like these Harvard professors, but the way he recounts the story, give the impression to the audience that justice has nothing to do, it doesn't even hear the word justice. What's justice? And then that word, my business, as opposed to the word used in the other two stories, job. Now, someone's job is someone's duty. Business is someone's interest. If you have a business, you have an interest in it. As opposed, if you have a job, you have a duty to do something. So in Judge Bork's view and Judge Hand's story, original story, Justice Holmes says, it is my duty to apply the law. Whereas in the Harvard professor's recount of the story, it's not duty to apply the law. It is the business. He is in a business of the law, and he is trying to just gain some advantage, some personal interest. Now, I spent 5-10 minutes on this because it's very important. Depending on what side, how you answer that first question, on the first slide, you would characterize Holmes as a wise man or an old man whose time is over. That's very important. And the divide that we have right now in the judicial realm or arena in the United States is pretty much traced back to this dichotomy of justice or application of the law. Now, we're going to talk about this a little bit further today. Hopefully, this story entertains you. If you have any question, I'm going to pause. I'd like this session to be very interactive. If you have any comment, if you want to share anything, please feel free to do so. You're hearing none. So, one of the when I said application of the law, what do I really mean by law? Law is one of the elusive concepts, means a lot of different things. You ask a Muslim believers, a Muslim, they're gonna say the law is Islamic law. You ask a Catholics, they're gonna say it's Catholicism. You ask a Jewish, they're gonna say it's the Ten Commandments. So everybody has a different perspective, a different view of the law. You ask an agnostics like me, and so like law is whatever the people decides. So what's the law? And we like it or not, the idea of the law was originated by religious institutions. And before that, human beings really didn't have any clear understanding of what the law is, what the order is. Now, whether you want to connect this to a superpower or not, that's a personal, you have to answer that question personally. I don't, but some people do. But that doesn't matter. When we're talking about the law, we need to understand what that word means. And pretty much everything we have today and we know as a law somehow traced back to the religious law. So St. Thomas Aquinas, about 700-800 years ago, it's a disservice to this great man if I condensed his thousands of pages of books into just one slide. But anyway, hopefully he forgive me. He said, when we talk about the law, we have we have four kinds of laws. One is the eternal law. To him, he was a Catholic priest. To him, the eternal law is the wisdom of God. Now, someone like me, I agree there are eternal laws, but I look at it as the law of gravity. It's a law that is always there, before us was there, after us is going to be there. Pretty much all of the laws of the nature, all of the laws of the physics are eternal law. So we have eternal law. Now, to St. Aquinas, the eternal law is the wisdom of God, because it's the God who knows everything, it's omniscient, it's all-knowing. So anyway, then he says from the eternal law, some of that is communicated to human beings in form of scriptures, divine text, call it divine law, Quran, Bible, Torah. But some of those laws are rationally discernible, and that's in the nature of the human beings. He called it natural law. Examples: you look at the nature, every single creatures in the nature, they know how to self-defend. They know the law of self-defense. They defend themselves when they are attacked. So that's a natural law. And that's rationally discernible. Just look at the nature. And then from natural law, humans adopt what he calls human law. But there is a difference here. He said human laws, unlike the other three, could be either just or unjust, because humans are not perfect. And then he adopts St. Augustine's, which another prominent figure in Christianity, view that an unjust law is no law at all and should not be followed, should be disobeyed. So to him, if we have an unjust law, he defines unjust law as something that contradicts directly the divine law or the natural law and the common good of the people, and we get to that in a minute. But to St. Aquinas, if the law is unjust, you should disobey the law. Now, of course, that changes in the age of secularization, right? The justness or unjustness no longer depends on whether the law derives from divine text or natural law. That's the basic idea of secularization or secularism. This has nothing to do with divine text. Humans can come together in a democratic process. They can adopt whatever law they see fit, even if that law contradicts the natural law. For example, in country of Denmark, you can't have anything for the purpose of self-defense because self-defense is illegal. Well, one might say, like, self-defense is just it's rationally discernible. You know, it's pretty obvious that people should be able to defend themselves in times of danger or when they are attacked, but no, not in Denmark. But can you say Denmark lies and just no, people there come together, decided that way. So that's just, you know, under today's measure, it's not unjust. Or property rights. Suppose there is a country down there, like a communist country, they don't have property rights, but suppose the people adopt this value. Okay, so what? They don't want to have property rights. I know it's against the law of nature. Everybody owns what they find or what they possess. The ownership interest is pretty damn significant in the law of nature, but some people might choose not to have it. Well, respectable, right? So long as it follows a democratic process. Now, also what I would like to say is about human law. Human law is comprised of 3 different components. One is the constitutional. In many countries, we don't have a constitution, but like in the United States, we have. The Constitution is essentially enumerate basic liberties that no democratic process can take away them from the people. Essentially, we have constitutions to protect the rights of minorities. Freedom of speech, example. We have freedom of speech because we don't want any majority be able to prevent a maverick, not well popular view from being spoken. We don't want that. So that's why we have constitutional law. Then we have legislative law. It's the one that's, you know, passed by Congress and by the people's representative. And these laws essentially have some democratic taste into it. And then we have common law. Of course, common law is the most undemocratic law you can find because it's decided by judges. Judges usually are not elected by the people, and they are appointed by the political branch. And judges get to decide cases and, you know, issue rulings that become law in cases when the legislative branch is silent or the Constitution has not spoken. So and pretty much most of these come from before the time we adopted the constitutions or we have any Congress or any representative body in our political system. People had controversy, they turned to these judges, and the judges had some principles of equity, for example, the principle of dirty hand or unclean hands. If you are accusing someone of doing some wrongdoing, you can't be guilty of the same wrongdoing. That's a common law principle, okay? But the good thing about common law is that there is an understanding both among the judges and our scholars that the common law can be replaced by the legislative law or the constitutional law. In other words, in the past, a judge defined certain crime as to require a mens rea. Mens rea means an intention, any element of intent. In other words, if you are to be committed of a crime, you need to have the sufficient intent for carrying out the act that leads to the crime or is known as criminal. So you need to have that intent. So in common law, all crimes had element of intent in them. Now, today's many crimes, some of the crimes, really you don't need to have any specific intent for the act. You just need to do the act. One example would be if, the statutes that are in place to protect the minors. You talk to someone, you ask them how old they are, they said, like, I'm 18, they lied to you. You ended up having some romantic relationship with them, and then guess what? You realize, or somebody, a police officer realized that the person you had a romantic relationship is really not 18, 16. Well, you didn't have the intent. As a matter of fact, if you know that the other person you're dealing with is not 18, is 16, you may even decide not to go forward, right? But the law says we don't care. We don't want the intent anymore. And that's how the common law is replaced by the legislative corrections, I would say. So, but the real question here is, when the human laws produces unjust outcome, what's the judge's duty? Now, of course, a judicial activist, a judge who believes his or her role is to do justice, is governed by some basic justice principle. One is that's often quoted by this justice lover judges. It is this one from the Old Testament, that justice shall you pursue. And although they believe in the principles of secularization, but still they believe that justice is something that needs to be observed by judges. And they rely on this scripture text to conclude justice is essentially different from application of the law, or could be different. Or in other places that they think justice must be served no matter what is where, you know, it's in the interest of the public. And the real question here is, who gets to decide what's the interest of the public? A judge who is not elected by the people, or the representatives who are elected by the people? That's the question. Now, to put it in context, a couple of years ago, a case went to the Supreme Court. That was a vaccination mandate for all private and public employment, private and public industries, requiring all employees in those industries should be vaccinated against COVID vaccine. And the case went up to the Supreme Court, and one of these justices of the Supreme Court, Justice Breyer, is a really decent guy, and has been retired. He continued questioning about the consequence of, you know, not letting this rule, this vaccine mandate stand. What would be the consequences? He's asking, you see, millions of people dying every day. The hospitals are full. Are you asking me, asking the lawyer, are you asking me to say, well, you know, we should stop this vaccine mandate under the current circumstances? So it's all about, like, it's a common good, it's a public interest. Why we should stop it? Why do you hate vaccine mandate? Why should you stop it? And the lawyer said, well, the question is not how the country deal with COVID vaccine. It's who gets to decide this. We don't want a judge who's not elected by the people to decide it. We want the people to decide this. So, you know, that's the answer to the justice lover justices or judges. Now, what I want to get at is actually the idea that judicial restraint, meaning looking at judges as only mouth of the law without any discretion, is actually bringing or leading us to justice. One example is Lord Mansfield in England. In England, around the 1700s, around the time actually the Constitution of the United States was ratified, slavery was a thing. So he gets to decide a case, Somers versus Stuart. Stuart bought a slave in Boston, which at the time was a colony of UK, right? Brought the slave to United Kingdom in London, and the slave escaped. And then he found this slave, and for punishing him or whatever, he put the slave in a ship to go to Jamaica and work in some like mine or whatever. As some, you know, some of his family members, the slave's family members, some of the, you know, the lawyers at the time who were against slavery decided to file a petition for a stay of this, like essentially it's a legal term, habeas corpus, to stay shipment of this slave to Jamaica. And Lord Mansfield gets to decide the case. He said, first of all, if slavery needs to be a thing in this country, it needs to come from positive law. Positive law means either constitution or what? Or the legislative branch. And I know that what would be the consequences of my decision. If I today say slavery is not a thing in this country and slaves are all free, well, we have like 200 years of slavery in this country. Everybody has a slave. And there's going to be a rebel of slaves in this country. I'm very, very aware of the consequences. However, let the justice be done, though the heaven falls. We don't care what the consequences are. The justice needs to be done. And he refers to justice as something that's whether in the law or it's not in the law. If it's in the law, it must be applied, must be done, and that's the justice. And says, whatever inconveniences, I cannot say this case can be allowed by the law of England. So there's no slavery. So now, let's go back 250 years, and the same logic as you said in the previous slide that Justice Breyer applied in the OSHA case, in the vaccine mandate case. Suppose that same mentality, the same attitude was endorsed by Lord Mansfield. Well, okay, I know the consequences of my decision. Although it's not in the law, let's say, we have slavery. So what? We had it for 200 years. That's the problem. When you focus on consequences of the law as a judge, these consequences changes for better or worse as time goes by. If you stick to the consequence, if you pay too much attention to the consequence of your decision, you may end up deciding cases that are not just. So, and it took me a while when I was studying all this, like, why justice can only be accomplished by application of the law, but again, the framework of what a judge does. And that brought me to Montesquieu in his landmark book that's still being taught on campuses and in law schools, The Spirit of the Law. He says, we don't want judges act like our representatives. They are not they're different from the legislative body. Because if they are acting like, if we give a judge too much power to act like a legislative, we essentially let that judge to rule us by his or her whim. And that's not good. That's not good. And he also says, I know the law that is codified by the Congress, or a constitution for that matter, it might, in some cases be severe. It might be leading to some bad consequences. I know that. It has the bright side, it has a dark side. I know that. But as we have already observed, the national judges are no more than the mouth that pronounces the words of the law. He's not kind of a guy not to see the consequences. It's like, I know there are consequences, but we don't want a judge decides for us on those consequences. We want the law be changed by our representatives, not a judge. Well, and later on he says, if a judge gets to decide a case based on what he sees right for the public, what he sees the most important consequence. We have a lot of consequences. Who gets to pick which one is important and which one is not? Well, a judge? No. But if a judge does so, then nobody knows what's the nature of their obligations and their rights. And that's something that we call in the United States the vagueness doctrine. The vagueness doctrine essentially says law must give an ordinary person a fair notice of what is forbidden and what is not, without judge interpreting that law. The law must be clear as to what's a right of a person and what's an obligation of a person. The law that fails to do so effectively asks a judge to arbitrarily decide the limits of a person's right or the limits of a person's obligation. Now, this is very important. And here I'd like to get to, a little comparison between a law in Iran, my homeland, and a law in the United States. They are pretty similarly worded. One is in the United States is declared to be unconstitutional because it's a wage, and the other one, no. There was a law in the state of Louisiana that says whoever with intent to provoke a breach of a peace, get together with other people, is guilty of disturbing the peace. So, but the law fails to define what's the breach of the peace. Discharging a firearm in public, could that be a breach of the peace? No, to some people, yes. What about a public demonstration on a public street, near a courthouse, near a hospital? Well, some people might view that as, disruptive, right? But what it is, breach of the peace. The US Supreme Court overturned, invalidated this law, says because it's vague. It's vague. You did not define breach of the peace. We have a similar law in Iran. The penal code in Iran says anyone who establishes and directs a group to perturb the security of the country, well, shall be in prison for 2 to up to 10 years. Well, what's perturbing the security of the country? Is that not equally vague? Now, what happens in Iran? Iran, this law is adopted by judges, and each judge gets to decide whether the accused act is under this law, is falling under this law. Sometimes you steal somebody's car, and that, you'll be convicted under this law in Iran. You have a peaceful protest, you'll be convicted under this law. You have an interview with a foreign TV, you will be convicted under this law. And that's the problem of vagueness. And if we let the judges go beyond what the law says, you're going to have a legislative branch who's as sloppy as the legislative branch in Iran, gives the law that's really vague, and then leave it to the judges to decide whether or not the law applies. That's what we don't want. So justice, to me, requires invalidation of the vague law, and no judge can remedy that vagueness. So I'm going to pause here and see if anyone have questions, because I'm just talking too much right now. Anyone?
Well, is it fair to say, can you hear me?
Yes, please.
Okay, yeah, my name is Manu Cherkasai. Is it fair to say that a lot of times laws are written not necessarily to protect the minorities, as you mentioned, but it is in the support of those individuals who are writing the law? So applying justice, sometimes it becomes extremely difficult if the law is written to protect those minorities that are actually dictating or writing the laws.
Yeah, a very great question. Thank you for asking that. So the 2 points. First, in a country like the United States, we are a liberal democracy, meaning we have certain rights in the Constitution that no majority can take those rights away. So no majority can come and says you don't have a right to speech, whatever the content of your speech is. But then, of course, there are laws. There are, aside from those rights that are enumerated in the Constitution, there are laws that I agree that are written to protect the interests of the majority. But it's almost impossible to form a majority on any single topic. And that's why European countries criticize the system of lawmaking in the United States. Like, it's really hard to make laws here. You have two body of Congress, one making law, the other one can, can disagree. Like right now, the House of Representatives is Republicans, the Senate is Democrat. They can't agree on anything. So, but that's exactly how it was intended by the framers. Because in this environment, you get to finally have the law that's approved by majority of the people. And of course, if you are in a minority, you have the political process available to you. Go convince your neighbors, persuade your fellow citizens to vote with you on certain matters. And an historical example would be the temperament era in the United States. 1920, 18th Amendment, the prohibition time, as some call it. So you can't have consume alcohol in the United States. Well, those who wrote that law were not willing to repeal it. So the people come together after 12 years, they repeal it themselves through the Constitutional Convention. So, that's, so where I'm getting at is not necessarily just because you have a majority, you're going to have laws that protect minorities. Another example is ADA, American with Disability Act. Well, God knows the number of disabled in this country is they're not in the majority, right? But they have laws to protect their interests. And that law was approved by a majority of the people. So it's hard to say that, just because you're in the minority, your rights are chipped away. You don't have a say. Not really. In a democracy, when people have, but people can talk freely and encourage other fellow citizens to side with them, sometimes minority can prove their desired course of action. So anyway, thank you for the question. Any other question? Good. So with that, I'd like to get to the jurisprudential tools. So we, as a judge, you have usually 6 tools to consider when you're trying to decide a case. The text of the law is the first and the most important thing. The law does what it says it does. And then sometimes text is ambiguous. It's hard to understand. So how we should understand the text? We will understand the text. I propose, or many people, originalist view is that we should understand the text in light of the history and tradition. History. Those people who write this law, 250 years ago, what did they mean by these words? The original meaning, the meaning at drafting. The tradition, 250 years is the gap between today and when the law was written. Within these 250 years, 25 generations came and go. And all those 25 generations dealt with this law. So the understanding of these 25 generations also matter, right? And then we have precedent. Precedent, I'm going to talk about that a little bit. It's a can of worms. I don't like to open that, but precedent is essentially the previous rulings and decisions and opinions of the courts in previous cases. Sometimes that could be binding. And then the consequent purpose. And as you saw in the previous slide, when you focus on the consequences, you're going to have a situation that you necessarily must say, Lord Mansfield got it wrong. The consequence of his decision was a pretty terribly dangerous. So he should have held that the law of England supports slavery. But he chose not to focus on the consequences of his decision. He just focused on the first 3, the law, the history, and the tradition. So with that, I'd like to pose to you a hypothetical thought experiment. And this is actually a case went up to the Supreme Court. And unlike all other cases that you heard, You never heard about this case. Nobody talks about this case because it's really not on a touchy subject. So suppose your friend is water skiing in a reservoir full of flood water. The government agent sees your friend and opens the drain. The stream of the water that's formed just kill your friend. It is gross negligence. Let's say that we agree that this is gross negligence. No government agent should do so when they know somebody is in the, reservoir. But then there is this law that says no liability of any kind should attach or shall attach to or rest upon the United States for any damage resulted from floods or flood waters at any place. Now the issue is if your friend can recover damages, or your friend's family can recover damages from the government for your friend's death. Now I'm going to give you a couple of minutes to read all the choices, and please let me know with the poll that our friend's going to share, and Mehdi is going to share. Let me know which one you're going to elect, which choice you're going to elect, you believe to be most persuasive. Give it one more minute. Okay. Okay, I'd like to hear from each of you who already voted. So someone please let me know why you found the second choice among those who voted for the second choice more persuasive than the others. Someone please. Don't feel pressured if you don't want to do it, it's okay. But I'd like to hear from you guys. Anyone? Okay. What about the fourth choice? Anyone's willing to share why they thought that one is most persuasive?
I thought the voting was anonymous.
Yeah, the voting is anonymous. I don't see who voted for what. I see the statistics only.
Yeah, so I voted for the second one. So let me tell you, breaking anonymity. Let me tell you why I did that. The issue would be, in my opinion, what flood means and what flood waters are, and one could interpret that as applying in this case or not. Now, because the basis of the argument is a law, you should try to interpret it as whether that law actually meant flood to apply in this case or not. So I don't think it would, given the intent of that act. And so I wouldn't I would think the act is not applicable to this specific case. Yeah.
Great. So you think that because the intent of the act was not this, therefore it's not applicable. Good. Anyone's willing to share why they registered vote for the fourth? That's okay. Anyone's willing to say why they voted for the fifth choice? Okay, so I get back to what Muhammad said. Well, yeah, the intent of the law matters, but the intent that is not codified in the law, how would you get that intent from? Who would you refer to essentially understand the intent or purpose of the law when it is not in the law itself? Now, usually the lawmaking process is like 200, 300 people come together and they agree to a language, and each of those come from certain angle. Traditionally, the courts used to go to a couple of those people from 100 years ago and say, like, look, this guy who introduced the bill, Congressman XY, he said it's his purpose, and therefore map that individual purpose out and extend it to the entire, generalize it to the entire Congress. That's not the case. You don't know really what was the intent of the other 299 members of Congress when they voted for this. You don't know that. So, that's the problem with intent. It's 100 years of time, yeah. And even if you find a couple of members said something here and there, how can you say that was the intent of the Congress as a whole? So that's the problem with intent. Now, one person, and I would like to get to number 4, because it's very tricky. It says, of course, the language is certain. It says no damage of any kind whatsoever, any place, whatever, right? So that any place, it includes the reservoir too, right? I mean, back to Muhammad's answer. It's any place means any reservoir. Reservoir is a place, so any place that would be included. But the problem actually is not this one. First of all, the language of the statute said for any damage, and the question presented to the court back in 1986 in the Supreme Court case was if Lily's estate, Lily's parent, Lily's husband, whatever, can recover damages. Now, from then, we call the death of a human being a damage. So suppose somebody died and you say, oh, what a terrible damage. Would you say so? Would you characterize death of a person as a damage? The dictionary definition of the damage, last time I checked, was, property damage, property harm. Human death is never referred to in common language, common English parlance, as like damage. Second, the word damages, although it's a plural form for the word damage, but has a completely different meaning. Damage means property harm. Damages means monetary award that is received by parties in the litigation. And there are a lot of words in English language. When they receive that plural S, their meanings change. Blind is someone who can't see. Blinds, is what you use on your windows. Premise and premises. One is a logical assumption, the other one is property. Custom, tradition. Customs is an organization. It's an entity. So the two are different. Just because the language of the statute says damage, first of all, it's not applicable to human death. Even if it was, that has nothing to do with damages that could be recovered on someone's death. Now, look, went to the Supreme Court of the United States and they did not distinguish. They did not appreciate the difference between damage and damages. Look what the court says. The word damage was ambiguous because it might refer only to damage to property and exclude damage to persons. The court rejects the lower court ruling on this. The lower court says, look, damage only applies to personal property, doesn't have anything to do with death of someone. Exclude, but the court says no. Why? Because damages, now look, the first sentence focus on the word damage, but the second sentence is damages have historically been awarded both for injury to property and injury to person. Of course, yeah, damages has a different definition as to damage, but the law says no recovery for damage. It doesn't say no damages whatsoever. It says no recovery, and recovery means damages, means no damages for damage, and damage means harm to personal property. So Lily's death would not fall under the umbrella of this statute. Now the Supreme Court says it does. You know, that's because there are not, you know, those who get to decide, they do not pay attention to the text closely. And the case, for anyone who's interested, U.S. versus James, 1986. So, another hypothetical I'm gonna share with you. Year 2020, you sign a lease with your landlord for 100 years. And for the sake of argument, let's assume that we're gonna live 100 years, okay? There is a provision in the contract says no pet shall be placed on leased premises. Violation is subject to $2,000 fine. 2030, you know, AI and, you know, the programming, everything, you know, get to a stage that we're gonna have robots pet year 2030, okay? They are made available, they are marketed for purchase. Year 2050, the robot pets become exactly like real pets, except that they are robots, they're not pets, and they can be programmed. The pets cannot be programmed. And suppose in year 2090, the term pet is used, even in dictionary, to refer to both domestic animals, the traditional pets, and robot pets. And in year 90 years from today, 2110, you buy a pet, but a robot pet, not a domestic animal. Now your landlord wants to sue you for violation of the lease. What should be the result? And the reason that I come up with this is not a real case. The reason I come up with this hypo is to emphasize, to underscore the importance of sticking to the original intent or original meaning of the words. This contract was written at the time. No parties to this contract could even fathom robot pets would exist. And just because the meaning of a word changes in course of 100 years, that doesn't mean that the landlord now has a right. And we're gonna have something similar to this. And soon I'm gonna talk about it, but the words of the Constitution change their meanings. The public understanding of those words change. One of these words is the word liberty. Liberty didn't mean what it means today 250 years ago. So which should be our time or frame of reference or you know, origin of time based on which we decide what liberty means? Today's understanding or 250 years ago? But if you say today, then would you be willing to be the tenant in this hypothetical and be sued for $2,000? Of course not, right? You don't want to be bound by a provision that's not applicable to you, right? The contract is silent about robots. Doesn't matter what people now believe about, you know, the generality of the word pet. When you signed this contract, you didn't mean pet to include robot pets. Any question? Great. Another hypo, and that's come from a real case. Usually law students also learn about this case. The Panera Bread had a contract with a shopping mall. In the lease agreement, they say, the landlord committed himself not to lease any other spaces to any food chain that sells sandwiches. And that's because, anti-competitive, we don't want to lease two sandwich stands to two different individuals. They're going to have a competition. It's not good. They're not going to be able to pay the rent. So we, for a lot of reasons. Okay. Now, the mall owner eventually leaves one space to a burrito stand. Now, the question is whether this mall owner is in breach of the lease contract. In other words, the question is whether burrito is a sandwich. Now, I'm an Iranian, okay? In Iran, we call falafel sandwich. We call back here 12, 13 years ago when I came, like burrito sandwich. I heard that word for, I'm dead sure about that. We call everything sandwich. If it's in a pita bread, if it's in like whatever bread, we call it sandwich. So the question is, like, what definition of sandwich should apply, should control here? A definition that's in the dictionary, that's in the mind of two Iranians. Of course, that depends on whether the parties to these contracts are Iranians. Whether this contract was executed in New York or California could change the answer, as you're going to see in the next slide. The sandwich in dictionary is defined as two slices of bread, usually buttered with a thin layer of meat, cheese, whatever. So the dictionary definition includes cheese sandwich. USDA says, United States Department of Agriculture. Well, it's sandwich is two slices of bread that must have meat in it. So under USDA definition, so if you sign this contract with the government, cheese sandwich is not a sandwich, because in sandwich, by definition, it should be meat. And of course, as to burrito, it says they are sandwich-like. They're not sandwich, they are sandwich-like. New York says everything in the bread, served with the bread, is sandwich. Burrito under New York law is sandwich. So if this contract is executed in New York, it would be sandwich. And the mall owner would be in breach of the contract. And in California, they only consider hot dog and hamburger as sandwich. So in California, you're good. The mall owner did not breach the contract. So what I'm getting at here by this example is the meaning that the people who write this contract had in mind when they signed it controls, not the meaning that a judge understands today. So we need to go back 200 years ago and understand what the drafters of the constitutions, what the ratifiers mean by the words they choose. And if we don't like that interpretation anymore, of course, we can change the law. So that was a pretty long introduction before I get to the Roe versus Wade. And that introduction that I just said and all those hypotheticals set the stage, because I want you to understand what my beef is here. I'm not at all against, I don't have a public opinion as to abortion is okay or not. I really don't. All I'm saying, the question that was presented to the court in Roe versus Wade and in all subsequent cases is whether abortion is a right enumerated in the Constitution. And if so, which word in the Constitution suggests that right exists? And the courts right up front says that we need not resolve the difficult question of when life begins. So that's not at all a legal question. And the court understands that many people with different points of view, pre-elections, everybody could have a different understanding or different view on this topic. But that's not for the court. The question presented was, does the US Constitution recognize a woman's right to terminate her pregnancy by abortion? If the answer is yes, then the second question would be, okay, you know, we know not all rights are absolute. Freedom of speech is not absolute. You can't go and tell a lie under oath at court. You can't defame someone under freedom of speech. You can't, then no rights are absolute. So if it is a right, then what are the limits of this right? But if the answer is no, if this right exists, should be determined by the democratic process. Good. So the court went through all these factors: text, history, tradition, and of course, it was the first case deciding this this issue, this question. So there's no precedent prior to Roe versus Wade. And then purpose and consequence. As for the text, the court concedes, the same court that says abortion is a constitutional right, says the Constitution does not explicitly mention any right of privacy or right to abortion. So the text of the Constitution doesn't say anything. The history, the court says the predominant view in common law, remember common law, as I explained, was the law way before Constitution was adopted, that the abortion was an offense, although a lesser offense. So when something is an offense, it could not be legal, right? Then also the court says, and the Hippocratic oath that the doctors took for centuries, for years, it says, I will not give to a woman an abortive remedy. So that's the history. So we don't have any abortion was not recognized as a right in history. Again, we are doing this because we want to understand the words of the constitutions. Remember, I don't agree or disagree. I mean, I don't agree or disagree with either side here in this battle. I'm just trying to narrow down the problem to the words of the Constitution and see if those words mean something that I could decide this case. The tradition after the Constitution was adopted or ratified, since years after that, still states criminalized abortion. And by the end of 1950, remember 200 years of generation, a large majority of jurisdictions banned abortion. So these generations that came before us understood the Constitution understood the document as it is not granting any right as to abortion. But then the court said, but then if we decide there is no constitutional right to abortion, we are going to have some problems. Again, a consequence-driven decision. Most women are in this stressful situation. There's psychological harm. You know, the motherhood, if you don't want your child, the motherhood is not going to be perfect. The child's not going to receive a good, maternal care. All of this. So the focus here, the focus of the court is in the consequence. Now, when the court said these consequences are terribly, terribly bad or dramatic, then we need to find somehow that the Constitution grants this right. So they said already that there is no express right to abortion in the Constitution. However, they said maybe implicitly, Constitution supports the right to terminate pregnancy. So they examined few hypotheses. First, they said the right was rooted in either First, Fourth, and Fifth Amendment, and then incorporated in the Due Process Clause of the 14th Amendment. For our understanding, the First Amendment is the right to free exercise. Well, historically and traditionally was understood to be related to the freedom of speech, freedom of opinion, freedom of assembly, has nothing to do with the exercise clause or freedom of religion has nothing to do with, abortion. So the court rejects this argument. Second, same court, Roe v. Wade says, the right of the people to be secure in the persons in the Fourth Amendment. Well, if women should be secure in their person, but then again, that's for governmental, infringement of your privacy. It's not about abortion. It hasn't been understood to be about abortion. So the court rejects that. This is the Fifth Amendment, talks about no person shall be deprived of life, liberty, or property without due process of the law. So the court says, and that's the closest argument the court could have, says, if we take this, and this was incorporated into the 14th Amendment. Now, historically, the First 10 Amendment were understood to be applicable to the federal government only. The 14th Amendment is understood to extend that to the, or oblige the states to give the same or acknowledge the same rights federally recognized in the Constitution. So that's a distinction. So the 14th Amendment says, no state shall make any law to abridge the rights of the citizens of the United States. And some of these rights are the rights to life, liberty, and property without the due process of the law. So they shall not be taken. The court rejects this. The court rejects this because, again, the word liberty, if we assume that the Fifth Amendment is somehow incorporated in the 14th Amendment, we must say at the time of the founding of the nation, these words, the word life, liberty, and pursuit, or the property, somehow mean in the mind of the ratifiers a notion of abortion. They couldn't do that because at 1787, there was no such understanding. So they rejected, the same court rejected its argument. Second, the right was founded in the Ninth Amendment, reservation of the right to the people. The Ninth Amendment says essentially, if any of these express rights that is codified in the constitutions, we enumerate those, doesn't mean that other rights cannot be recognized. They are reserved for the people. And the problem with this is, it's a notion of democracy, right? It says it must be decided by the people of different states through a democratic process, right? It's not like if I just wake up and says like, oh, I think I have this right and I'm gonna act based on that right. No, I need to, make that right a recognized right within a state or within a nation, so through the democratic process. So this doesn't do any good to the court either, because yes, abortion is not expressly stated in the Constitution. So if it is reserved to the people, then people should get to decide. It's not constitutional law anymore. It could be a legislative law, as it is a legislative right, as it is in many states right now. The third hypothesis is equal protection clause. The equal protection clause essentially says, any law that discriminates on the basis of sex should be unconstitutional. The problem with this is, the argument goes like this. Because the abortion is a medical procedure that's used exclusively by women, forbidding or regulating it is essentially violating the equal treatment of the women and men, because women are treated much poorly by not being able to make that decision. Well, the problem with that is there are many medical procedures that are that is used only by certain sex. For example, abortion is an example of a medical procedure used predominantly, by women. But then there are some vasectomy, for example, is something that's used by men, right? And independent from who's on the receiving end of it, the government can regulate a medical procedure, so it doesn't have any discrimination into it, at least constitutionally, right? And the fourth hypothesis, the court says, it is within the liberty, it is within the meaning of liberty in the 14th Amendment, where the 14th Amendment says no state shall deprive any person of life, liberty, and property without due process of law. And the court says, well, this right of privacy, it be founded in the 14th Amendment as we feel it is. You know, you wouldn't find many legal opinions that says like we feel it is. I remind you what Montesquieu says about the feeling of a judge. We don't want a judge to feel for us. We want them to show us evidence that this right was recognized 150 years ago. So again, the problem is we feel it is. There is no proof, no nothing that says this word liberty meant to include the concept of abortion 150 years ago. As a matter of fact, the court itself says it's not, because it says up until 1950, all the states criminalize abortion. And again, compare this with the Montesquieu's view of judiciary, that, you know, we want judges to be mouthpiece of the law. We don't want to hear from them what they feel or their personal opinions. But finally, I'd like to pose the question to the audience here. Why did the court favor this hypothesis, number 4, over the first hypothesis? You see, the first hypothesis says it is within the 5th Amendment incorporated into the 14th Amendment. And the 5th Amendment has this language again, deprived of life, liberty, and property without due process clause. The 14th Amendment has the exact same language with the addition of any state. See the red line language, this is the same. The word liberty was not introduced in the Constitution the first time in the 14th Amendment. It was introduced in the 5th Amendment, like at least 90 years earlier. But why the court sticks to the 4th hypothesis, not the first one? And the answer is solid. It's a very, very detailed, solid question. The answer is, if the court has to say it comes from the 5th Amendment, the liberty in the 5th Amendment recognized the right to abortion, the court needed to show that that in the year 87 or 89, the word meant to include abortion. However, the 14th Amendment was ratified in 1868, about 90 years later. A court hopes that the concept of liberty, and again, I told you, I discussed this, that the meaning of the words changes, you know, from one generation to another generation. The word liberty that used by the first generation in 1787 definitely did not mean the same thing as that word was used by the 1868 generation, right? So the court was hoping if we come a little bit closer to the present time, you know, and this case was decided in 1973, then we can say, you know, liberty include or subsume a broader meaning, or had a broader meaning in 1868 comparing to 1787. And that was a hope, but again, the court didn't prove that. The court just said, we feel it is. Okay. I would like to draw your attention to another case. That judicial restraint, it shows judicial restraint does not necessarily mean such rights cannot be implemented or cannot be recognized through a democratic process. There was a case actually from Missouri, where I am located right now, Minor versus Hopperson. Minor was a woman, wanted to vote, and Missouri Constitution did not recognize the right for voting to women. And you know, she took up the case to the Supreme Court. The Supreme Court considered the case, and the Supreme Court says, you see, the question is whether citizenship or whether voting rights come with the citizenship. If we have a U.S. citizen, does that U.S. citizen, by virtue of his or her citizenship, is entitled to vote? If the answer is yes, then voting becomes a fundamental right and is protected under the 14th Amendment. And therefore, the 14th Amendment says you can't discriminate between men and females. Therefore, Missouri not letting this woman vote is unconstitutional. But the court says that's not in the Constitution. Nowhere in the Constitution says citizens should have the voting right by the virtue of their citizenship. So that's not a fundamental right. When it's not in the Constitution, it is left for the people to decide. And the 14th Amendment says it didn't add any new rights to what we already know citizens have. And we knew at the time citizens did not have the voting right as a fundamental right or constitutional right. And it says if the Congress had been intended to make all citizens of the United States voters, the framers of the Constitution would not have left it to implication. They would have said it. But the court also says, if the law is wrong, if this decision, you people believe this decision is wrong, it ought to be changed, but we are not the one who should change it. You should resort to the democratic process. And guess what? Less than 40 years later, the 19th Amendment was ratified, recognizing the voting right as a fundamental right of each citizen. And therefore now, the 14th Amendment applies, and nobody could discriminate against voters or citizens on the basis of their sex when it comes to voting. So for those of you who might say, like, the court decided Roe, there's no way for us to get the rights in Roe codified abortion right now. You could get it. We could get it by convincing our fellow citizens to vote the same way as we would like them to vote. But please don't come back to me and says this vote that for 250 years means something to the exclusion of certain concept. Now all of a sudden a judge failed. It includes that concept. That's not democracy. That's different from democracy. Okay, and finally, I'd like to say a few words about the doctrine of stare decisis. It's the doctrine of respect for precedent. In one of my papers, I call stare decisis a pernicious doctrine. And I compared that doctrine to a story from Paulo Coelho. The Paulo Coelho story goes this way. There was a cat, a Zen, a very famous Zen in a Buddhist congregation, had a cat. And every time they had meditation session, the cat came along, sit next to this Zen. The Zen was good. Zen, at some time later, dies. The cat was still around. The Zen's students keep the cat to respect the memory of their teacher, the main god. Then a couple of generations passes, the cat dies. Now the students feels like, the cat is actually an indispensable part of the meditation. We need to have the cat. So they're gonna go, they get another cat and leave it there. 100 years later, books came out talking about the importance of cat in Buddhism religion. Well, another 100 years went by, and some other Zen came by, and he was good too, but he was allergic to cats, so he ordered no cat in the temple. And then they saw that we could live without cat. We can do meditation without cat. And Paulo Coelho concludes by saying it took them 200 years to understand why the cat was there in the first place. Now, the doctrine of stare decisis, I always, if someone comes to me and says, like, this is the present, this is the previous case decided this matter, I take that with a grain of salt. Because it might be decided falsely. It might be decided, somebody might have erred in deciding that case. That would not relieve a judge's obligation of going through all of these factors, text, tradition, history, to see if really the rule of the law is what the previous case got. So I don't like the stare decisis because it blinds judges. it makes their life easier. They need to go through that exercise of text, history, and tradition before deciding a case. Just because a former judge, a former colleague decided certain way, that does not relieve themselves of their obligations. Justice Harlan, the second Justice Harlan, was known to be advocate of stare decisis. And even he said, when I find error in a stare decisis, I do not let that blind me. And I will depart from a stare decisis whenever I find it wrong. And Justice Douglas said, why? Because it is the Constitution that the justices take an oath on to support, not the words of the previous justices or the previous courts. So with that, I'd like to conclude by saying three things. A judiciary power that prioritizes justice before law will get to neither justice nor the law. Whereas a judge that prioritizes the law may not achieve perfect justice, but it's on a close approach to justice. And finally, faithful application of the law requires adherence to originalism, traditionalism, and restraint. And with that, I'd like to thank you for your attention. Thank you for attending the talk. Sorry, I talked too much, and I'm here for any question that you may have.
Excellent. Thank you. Thank you very much, Homayoon. It was a very interesting and informative presentation, so I appreciate that. So before starting the Q&A, I would like to say that since we are recording the session, please feel free to keep your videos off if you choose so, and you can also rename yourself if you want to do that. I will post these Fly Bottles social media channels in a few minutes in the chat, so please connect with us through them. So if you have any questions, please raise your virtual hands and we'll proceed. Okay, I think people are digesting your long presentation.
Or sleeping, or dozing off.
So let me start with my question. Okay, well, we know that that society is evolving, and but the Constitution is meant to be static and be stable. So that's why we call it the Constitution. We want it to be fixed. And your proposal, as far as I understood, is that we can add amendments. But what if, I don't know, some majority in some time decide that we don't need this amendment anymore? Can they remove amendments as well?
Oh, and yes. The procedure for that is very straightforward. I gave an example during the talk. In the temperament era, the prohibition era, they codified an amendment that the consumption of alcohol is prohibited in the United States. 12 years later, they just repealed it. And there are even current understandings of the constitutions can be modified through constitutional amendments. In the case of the voting rights, for example, the understanding at the time was that the voting is not a fundamental right of citizens of the United States by the virtue of their citizenship. That understanding was amendment by the 19th Amendment. So yes, you can get rid of, or slavery was amendment. Slavery was repealed by an amendment following the Great War between the states. So yes, if you don't like something, you can change it. And that's how it was intended by the framers of the Constitution.
Great, thank you. Surush, go ahead.
Can you hear me?
Yes, I can.
Yes.
Okay, thank you so much, Homayoon, for your talk. It was really interesting and difficult for me to follow, to be honest, because I don't know much about law and your field in general. I was wondering if you can clarify once more what the principle of originalism is and how we can use it in practice. If I understood it well, probably I'm wrong, but it's basically the idea that, so thinking about your example of pets, I need to go back in time and try to understand what the term pet meant by the time that the law was written down, right? So how this process works, how I can really understand what it meant to those people. You said it briefly, but I was just wondering if you can just clarify.
Sure. Very, very insightful questions. Very insightful. Thank you for asking, Sosh. See, I've never said it's an easy process. Originalism, yes, requires you to go back in time and try to find the meaning of the words as they were understood at the time it was written. At the same time, we're not talking about like 2,000 years ago, we're talking about 250 years ago. Still, a lot of stuff are documented, and we could reach to those resources. Of course, it's difficult. It requires a lot of reading. We need to find dictionaries from around the same time. We find letters and publications from that time. We also consult to a degree, especially in the United States, with the common law of England, because we believe we are essentially departed from the law of England at some point. So that is still available to us, or how the England codified through the act of legislative certain rights or certain laws. So, but I never said it's easy. All I'm saying is that there is no better alternative than this one. If the alternative that the living, the notion of living constitution is that the meaning of the word changes from time to time, if that's your if that's the alternative that I hear of, that's not good at all, because of the structure, the structure of the government we have in the United States. We have a judiciary that's not elected by the people. They are appointed by the president. And these 9 people there, they get to decide what they feel. Again, I'm going to emphasize that what we feel this word means. That feeling might not be the same as the feeling of the people, right? We need to let these decisions be decided by the people of the United States, not 9 unelected justices of the Supreme Court. That's the entire, and there is a notion of democracy in this. When we talk about judicial restraint as one of the tenets of originalism, we say, like, look, judicial restraint means when the people have the representatives in the Congress, when they can participate in the voting process, they can have the law changed through that democratic process. I don't need, as a judge, to say anything about something that's not my job. I don't need to stick my nose where it doesn't belong to. I am a judge, needs to interpret the written law. And the law, if produce bad outcome, tough luck. Rubbish in, rubbish out. You write bad laws, that would be the bad consequences of the law that you write. If you're not happy with the consequences, change the law. But I'm not going to do it for you. That's originalism. Hopefully I answered your question.
That was great. Thank you so much, Homayoon.
So Homayoon, I have a follow-up question to that. This is Zaina Frasiab. Is the alternative then that you are proposing, or I guess that is rooted in originalism, would be that a different branch of the government is then kind of taking up the torch to do the will of the people by issuing legislation, passing legislation to give the judges something new to interpret if the Constitution itself doesn't produce the most just outcome?
So thanks for the question, Zaina. Very thoughtful. You know, I don't believe so. I don't think any new branches of government needs to be instituted for that, because you know, yeah, you know, Constitution. Again, when you try to connect the notion of justice to human law, I need to go back to what I talked about Sant Aquinas in the beginning of the talk, because we're no longer in that framework. We are in the area or the age of secularization, that human law can very well be unjust if they are popular. I gave you an example. In Denmark, I believe nobody doubt that self-defense among us should be a fundamental right of a human being, right? I mean, you are attacked by some crazy folk in the street, and you can't defend yourself in Denmark. If you do so, and the dude gets harmed, you go to jail for that. You can have a pepper spray in Denmark because that's the only intended purpose of the pepper spray is for self-defense. You can't have it, it's illegal. So yeah, it's not just, but it's the law. Now the judge has nothing to do with, it doesn't have to worry about justness of the law. Who has to be worried about that? The people's representative. The people of Denmark, you know, they need to come to their senses with all the respect and say, like, look, we need to have self-defense recognized, or otherwise we're going to get killed on the street and we can't do anything about it. So long as go ahead, please.
Sorry. So is the legislative branch in the United States the people's representative? Like, they should be passing better laws for the judges to then interpret to exercise justice?
That is correct. Yes.
Okay.
Yes.
Thank you.
Sure. I see a question in the chat.
Yeah, would you mind reading it?
I read it, or the question, the one who asked the question.
So if the one who...
Okay, I read it.
Okay.
Probably, yeah, the person, our friend, wanted to be anonymous. Legislators usually have a hard time passing laws, and laws are most of the times the result of big compromises. How would judiciary distinguish whether or not vagueness is intentional in a piece of legislation to keep it open for interpretation? And if we can determine vagueness has been intentional, what's the course of action? Well, the course of action, the second question is easy. Thank you for asking that, by the way. The second question is very easy. If the vagueness is intentional, well, we're gonna kill the law. Much like what happened, let me share my slides again. Much like what happened in, because this is, okay. Okay, much like what happened in Cox versus Louisiana. The breach of the peace was not defined. I don't care why it is vague. You know, that's what, if you want justice, really, you should say as a judge, I don't care why it is vague. It is vague. It doesn't provide fair notice to a reasonable person as to what constitutes breach of the peace. But yeah, I mean, in Iran, the example on the right, the security of the country is an obscure term. If we had true judiciary in Iran, we would say, like, the judge should have struck down this law as being vague. So yeah, I mean, I don't care. I mean, a judge should not care why the law is vague. We just can see it's vague. And now the vagueness resulted from you mentioned it's because the lawmaking is a hard process, and that's why vagueness is introduced within the process, because a lot of compromise and stuff. Like, yeah, sure, that's how it was intended to be by the framers. But at the end of the day, If you put something in the law, it's the law that governs, not your intentions. If the law is not vague, but produce unjust results, well, you know, they needed to do more compromise to make those unjust results go away. That's the point. But thank you for your question. Any more questions?
This is Zaina again. I have one follow-up. So
sure.
I think I have a much better understanding of originalism than I did at the start of your talk. So thank you for explaining everything. I guess I'm following the rationale very closely and am, you know, leaning towards agreement with, you know, the underlying tenets of originalism. One potential problem that I think we see in this interpretation is that the judges on the Supreme Court, I don't think the Constitution requires that they be judges, but they have all been judges so far, are uniquely educated to be able to interpret and apply law in this very complex way. But the people who are tasked with you know, exercising the will of the people of the United States, the legislators, they don't necessarily have a background in the law. I'm sure there are legal minds involved in drafting legislation, but there's a disconnect, I guess. So the people who are supposed to be drafting laws don't have the legal background, but those interpreting them do. Is there anything in originalism that, you know, accounts for that or kind of takes away that issue?
Sure. So first, I give you one example of a justice of the Supreme Court that was not actually a law major. Justice Robert Jackson. He was not even a lawyer. He even didn't go to undergrad, but he studied law. He self-studied law. So you don't have to be a lawyer to be in the Supreme Court. But I understand that, like, lawyers understand these principles much more easily than the rest of the population. But to your other question, that you know that the people who write the law may not understand the subtlety of drafting and the interpretation.
Exactly.
You know, yes, that's true. But you know, they're elected by the people. You know, at the end of the day, if you don't like it's not Iran here in the United States. If you don't like your elected representative because they really don't understand this, well, you know, go what requires in a democracy, but do what requires in a democracy. Talk to your fellow neighbors, or maybe you yourself, Zaina, run for office or run for a seat in the Congress, because you know a congressman from, I don't know where you are, but from your town is not, from your district is not good enough. It doesn't understand the law. You understand something. You have something to offer that the incumbent cannot, then run for the office. But putting it on the judges to correct the mess or slop created by the legislative, that's not right. That is against originalism, and that would invite arbitrariness, which I don't like. Now again, if you focus, I give you the Lord Mansfield example again. If you focus on the consequences, you're running a risk of saying slavery is okay. Now, back in 1770 in England, slavery was predominantly recognized by the people. But Lord Mansfield says, well, look, I don't care about the consequences. This is not in the law. And you know, I know it's a concern, but at the same time, according to Yankees, it's a free country, right? You go run for office. So we have a question in the chat. Would you say that the placement of Supreme Court judges by the president results in more unjust common law? especially when presidents abuse such power to gain a favorable interpretation of the Constitution? Well, you know, this is a very, very good question. Thank you for asking. But quite honestly, out of 60 or 70 decisions of the Supreme Court each year, probably only 25 to 30% of those decisions are 5-4 decision. By 5 means 5 majority, 4 dissents. It's like pretty divided decision. And those 5s are not always the same. So let's say President Trump appointed 3 justices, and not all of them agree with him. Another example would be 2 Republican presidents around 1980 and 1990 appointed 3 justices, Justice O'Connor, who just passed away a few days ago, and Justice Souter, and Justice Kennedy. And guess what? We all know how Reagan and Bush, the father, thought about abortion. But they casted the critical vote to uphold Roe in Casey versus Planned Parenthood. So it's not that because because a justice is specifically picked by a Republican president or a Democratic president, I mean, they're gonna just, it's clear how they're gonna vote. It's not really. Again, 75% of the cases you decided each year are at least 7-2-8-1-9-0, meaning the decision is unanimous. So, but yes, the presidents might go after judges or might pick judges who are, progressive or originalist. So it's different. So usually these justices do not have a public opinion, just like I never shared a public opinion as to the issue of abortion. You know my judicial philosophy, but you don't know if I agree with it or not. Maybe I am. So president doesn't know that. I mean, I don't have a crystal ball. I don't know if in their private they talk about it, but I guess not. President only knows a typical judge judicial philosophy, and based on that, whether he's originalist or not, picks them. And sometimes even those judges who picked by Republican presidents may break ways from the orthodox Republican view. Hopefully that helps. Any more questions?
Okay, let me ask another question.
Sure, go ahead.
So you introduce us to originalism. So what would be the opposite camp? What do you call that? And what can you explain that a little bit? And what is their major weakness?
So the opposite camp is focusing on consequence and purpose. And they are often called progressive. I call them consequentialist. And the example of that was again, let me share my screen, the OSHA transcript I shared from the Supreme Court case that, to share that one because it's easier to talk. Okay, this one. See, if you read the transcript about this vaccine mandate, Justice Breyer acknowledged that the argument for the opposition, meaning those who oppose vaccine mandate, is very strong. He said that. He said, the argument is very strong. But do you want us to state, essentially, to declare that vaccine mandate is unconstitutional or is not okay or unlawful or abuse of power, specifically when we see a lot of people dying, a lot of people in the hospital? Do you think, given these consequences, do you still ask us to do it? See, that's focusing on consequences. Now, the problem with that, to your question, Milton Friedman is a great economist, Nobel laureate. He has he said something very incisive. He said, see, look, when the government decides cases, when the government pass regulations, they usually have some seen consequence, seen effect, and a broad ocean of unseen effects. And usually only the seen effect, that's very narrow, was studied by the government before passing or introducing the regulation or the bill. But the vast majority of consequences that are very relevant are not seen and they were not intended, but they come to existence. The problem with judges going out there actively to find consequences is like, first of all, you don't have the resources. You're not a legislative body. Legislative body have a lot of researchers, have a lot of committee. They can do all these studies. A judge who has to decide a case within a couple of months, he doesn't have the resources to go out there and find all the possible consequences of a certain decision or a certain action. So he has to pick one. And the problem is, who made this judge the king to say this consequence is more important or drastic than all other consequences? That's the problem. That's undemocratic. So that's why I was like, we need to stop caring about consequences. We don't want to focus on consequence. It's not the judge's job. They don't have the resources for that. Hopefully I answered your question.
Yes, thank you. Thank you so much. So our time is almost over. If there is no other question, I would like to thank you, Homayoon, for your excellent presentation. Thank you very much. And I would like to thank our audience for being here, for participating, and for your great questions. This was our last presentation in 2023. So hopefully see you all in the next year.
Thanks. Thanks, everybody. Take care. Bye.
Thank you. Bye, everyone.
Thank you.